higher than they were before he learned of this application for his extradition. In other words, our having filed the application for his extradition, his propensity to flee is higher, or I dare say at the very highest. Now we've shared, related to that, we've shared the nature of the evidence, or the nature of the allegations against him. The nature of the evidence, while this may not be a key factor, but it is a factor nonetheless, that the respondent is now aware that we are alleging, or the United Kingdom has alleged, that he killed his girlfriend, and that there are related transactions between him and accounts of the girlfriend, so that we argue that we have overwhelming evidence transmitted to the Republic of Kenya from the United Kingdom against the respondent, and with the nature of the overwhelming evidence, the propensity of fleeing is at the very highest. It is for those very reasons, Your Honor, and with the indulgence of the court, that the court may fast-track the application for extradition, that pending the hearing and determination of that notice of motion, this court grants an order in the nature of custodial orders, holding the respondent pending the hearing and determination of the notice of motion dated 24th June 2026. I humbly submit, that's all. Bunch of copies, you have copies? Which we will charge fee for. And finally, Your Honor, that the seriousness of the offense is an important consideration has been upheld by Justice Fred Ochieng in Republic versus Ahmed Mohamed. He says, however, having taken into account the gravity of the offense with which the accused has been charged, and bearing in mind the fact that if he were convicted, he could be sentenced to death, I find that there is a real possibility of the applicant being tempted to abscond from jurisdiction. Again, we are dealing with the offense of murder here. That's the third one. I would have gone to the fourth one on Article 49(1)H, but Your Honor, let me address you on the question of whether or not the respondent has been in custody for 19 or 29 days. Mr. Hagai says 19, Mr. Pugh says 29. The Constitution of Kenya, Article 49(1), talks about detention continuing. Detention continuing. And it says, where an accused person is presented before court, the court shall tell them, 1, release them on bail. Number 2, inform them for the reason of detention continuing. It is true that the respondent was arrested on 10th. It is true that he was presented to court on 12th of June. He was informed of the reason for detention continuing by dint of a miscellaneous application. He was not arbitrarily detained. That miscellaneous application was closed because we had then filed a formal application for extradition. So that even as the respondent is in before court today, he is here by dint of the processes of this court, a judicial process. That judicial process cannot be an arbitrary detention of a respondent. And in conclusion, Your Honor, say maybe 2 things. Number 1, Article 24 of the Constitution, and we agree with our colleagues, provides for the manner of limitation of rights. Number 1, that this right does not fall under Article 25 and therefore is a right that can be limited. They admit. Number 2, that this court should give the least restrictive measure. We agree with them, and we say that in the circumstances of a man, a Kenyan, who has killed a Kenyan girlfriend in the United Kingdom, ran back to Kenya, has an old passport according to them, has a new passport according to them, and had a permit according to them. in the circumstances, releasing him on bail where he faces surrender to the United Kingdom to face murder, releasing him on what they say cash bail, would be, I dare say, reckless on the part of all of us. So that the least restrictive measure in the circumstances is to deny him bail, but fast track the hearing of the motion. Your Honor, as I sit, Section 107, 108 of the Evidence Act, but for purposes of our argument, Section 111 and 112 of the Evidence Act provide for circumstances where the burden of proof shifts to the respondents in matters which are called matters within the special knowledge of the respondent. And that takes me to the first rebuttal point. It is them that know that he was born in Eldoret, special knowledge. It is them that know that he has a mother, special knowledge. It is them that know that he was born in Kenya and lives in Kenya, special knowledge. We cannot be told that they led us and gave us 19 days to establish that he's living in Eldoret. If they have failed to tell the court that, they have failed to prove that, the burden was on themselves. We have said enough to urge you to find that the respondent should stay in custody as we hear the notice of motion dated 24th June. I thank you.